Um, okay. So
Great.
should I start up? I have some little slides here to get us started. Can I share the screen? Oh, you gotta give me permission. Okay, here we go. All right. Since I'm the MC for the evening. Okay, so okay. Okay, so welcome everyone to the first of hopefully many uh, iterations of the St. Louis Arts Chamber of Commerce Speaker Series. We're hoping to do one of these on the first Thursday of every month, and have topics of professional interest to artists and art workers. So people who are arts. We're not just featured. So we're not just focused on artists, but also people who are working in arts administration or in businesses that support artists. So uh, and in all disciplines. So, who is the Arts Chamber? We are a membership based collaborative of artists and patrons who are committed to establishing the greater St. Louis region as a premier arts destination. So, we do a lot of collaborations with different businesses and organizations within the St. Louis region to develop sort of do a lot of destination marketing and developing arts programs that will bring attention, bring vitality and cultural engagement to different areas of the St. Louis region, and also creating opportunities for artists uh, through those collaborations. We're an advocate for all genres and mediums of the arts, which means are we cast a broad net. We cover visual arts, music, performing arts, creative writing, literary arts. Um, we have we even touch on design and architecture. Like we have a very expansive view of what who is an artist, what is an art form, and what is an artist's role in the community, and how can art serve the community. We aim to build a strong network of individuals and organizations with a shared interest in promoting and supporting professional growth, artistic expression, and community engagement. So, helping artists develop as professionals is one of the reasons why we've started a speaker series, just so artists can, our members and also people in the arts community can meet once a month, hear from a informative and inspiring speaker, and learn about topics of professional interest to artists, and learn new skills, share skills, learn about trends that are happening in the art world, different art worlds, um, and business topics that will help their careers. So you can become a member of the Arts Chamber. We want members. Please consider joining. We so some of it, we have tons of membership benefits. But what big one is discounts on education professional development programs, including free access to our monthly speaker series. If you become a member, you can come to any speaker and come to speaker series any month, and it's absolutely free. Um, Whereas for non-members, you have to pay $5. So it adds up, and we've got a great roster of speakers lined up. And also, maybe come to a speaker that you wouldn't usually come think of coming to see, and learn something. You can learn things from other disciplines, and also you can meet other people who are working in the arts and build that network. You'll have access to our online professional development resources hub. So we're all working on putting together an online hub where we will store all of our educational resources so that members can access them on demand. So all of our speaker series will be recorded, and you could be able to go to this hub and watch the videos. We'll have courses available on there, downloadable resources. It's going to have, it's just going to be like you become member, just all sorts of goodies you can access anytime, whenever you need it. And then members also have access to mastermind groups, which we are just beginning to accept applications for. Sandy, would you like to go a little more detail about what the mastermind groups is?
Sure, I can do that. And I'm going to ask you to check. I think we've got 2 people who wanted to join us. Oh, there's one that's just joining us, and there'll be one more. The mastermind groups are informal groups of artists and art supporters who come together once a month, literally to hold each other accountable. So Linda, like you mentioned, that you're going to be working with different organizations and they're going to have different goals. The beauty of the mastermind group is that we come together, it's completely confidential, nothing can leave the meeting itself, but you can talk about, okay, what are the challenges? What does everybody see as ways to address those challenges? And then in the next month, you would come back and say, this worked or this didn't work. And in other words, the peers would support each other in holding each other accountable for actually running their businesses.
And that accountability is really important, especially for artists and creatives. Because for a lot of artists, it's your side gig. So it's easy to be like, oh well, I don't. Maybe I can not do. Maybe I don't have to do that goal that that thing that I need to do to reach my goal. Maybe I can slack a bit. You need the accountability.
The original mastermind groups, as an example, one of the earliest ones and one of the critical ones in the arts included Degas and other artists in the Impressionist movement. And in fact, that's the group that created the Impressionist movement. They supported each other and created an entire movement in the arts. So that's the beauty of a mastermind. It's a peer support group.
And the other influential one is the Inklings, which was the writers group that included C.S. Lewis and Tolkien. They would share each other's writing and get feedback, and yeah. So it's got quite a legacy. So if that sounds like something interesting, we will have more information available soon about how to sign up for a mastermind group. And
please do. I'm waiting for, I order a mastermind journal out of Michigan every year.
Oh, okay.
So that's perfect.
Well, we will be in touch then. Yes. Okay, so tonight's speaker, let me introduce him. So tonight's speaker is Mike LaBozzetta J.D, who is actually one of our board members. Mike has worked with Fortune 500 companies to evaluate their transfer pricing, international tax positions, and risks. As a student attorney at the Community Economic Development Law Clinic and the St. Louis University School of, can't quite say, I'm going to assume it says law. Sorry. Mike worked with members of St. Louis community who were looking to open their own nonprofit entities to serve a need they saw as going unfulfilled. What's passion these people have for the passion these people have for their community inspired me to support organizations as these organizations are critical to building a healthy community. Mike has a JD from the St. Louis University School of Law, MBA from the Cook School of Business at St. Louis University, and a BSBA in International Business from St. Louis University. So he knows his stuff, and he's going to help us learn. And he has, worked with tons of artists and creatives, and so he has that perspective as well. And he's going to teach us all what a working artist needs to know about contracts. Okay, Mike, I'm handing the floor over to you.
Thanks, Adrian. Thanks for joining us, everyone, tonight. Seems like we're a pretty small group, so if you've got a question, feel free to jump in. There's no need to wait till the end. I'm sure we'll have plenty of time to cover all the topics. So jump in if you want, and if you're one of the people who wants to wait till the end, that's fine too. So however you want to ask questions, the important thing is that you ask. I am going to share my screen. Let's see.
You should.
share screen. There we go.
You should be able to.
Do I have the capability to do that?
Yeah, I think I made it so everybody can. Yep.
I think you meeting start share. There it is. All right. Everybody should be able to see my PowerPoint at this point.
Mhm.
So this is contract basics for creatives. First of all, I am an attorney and we do like our disclaimers. So the choice of a lawyer is an important decision and should not be based solely upon advertisements. The Missouri Bar requires me to say that, and weirdly, this might count as advertisement for my services. So you have been disclaimed. Also, this is being provided for informational purposes only. It's not meant to be taken as specific legal advice. I would love to talk with you all if you have specific questions in a private consultation scenario, but this is for informational purposes only and does not create an attorney-client relationship. A quick outline of what we're going to do tonight. First, the anatomy of a contract. And then one of the big questions that comes up is, does a contract have to be written? The general answer is no, but there are some cases where it does have to be written down. And that's what's called the statute of frauds. And then before we get into licensing, we'll do an overview of intellectual property because a lot of licensing is tied up in the basics of intellectual property. So copyrights, trademarks, and patents. First off, the anatomy of a contract. Legally speaking, there are some elements that have to be included in a contract for it to be enforceable. Offer, consideration, acceptance, and mutuality. Offer and acceptance are kind of, they're what they sound like. There's an offer made and there's an acceptance by the other party. I will paint you a painting for $500. Offer, yes, I will paint you a painting for $500. Yes, I will pay you $500 to paint me a painting. Offer, acceptance. The consideration in that is the mutual exchange of benefits. The one person gets the painting, one person gets the money, and that mutuality, the mutual understanding is what makes the contract. So as I said, it doesn't necessarily have to be written, except in certain cases, which we'll get into, but having a written contract means you have a written memorialization of the risks and rewards that are being borne by each party. So if there is a dispute, you have a document you can go to be a basis for what that understanding was and should be interpreted as. Typically, the two main chunks of a contract are core terms. So pricing, delivery, what happens if there's a breach, what is actually being exchanged, products or services. And then a term you hear quite often is boilerplate. These are things that could apply to any contract, kind of regardless of what the nature of the contract is. So choice of law for those who deal in multiple jurisdictions. And so Missouri, Illinois, different states, different areas. You can actually have a clause in your contract that states if there's a dispute, if there's a lawsuit, if there's something like that, it will be handled in Missouri. So if you're doing these sorts of deals in multiple places, it can be advantageous to you to have this in your contract so that if something does go wrong, at least you can go to a local court and find local help instead of having to go to a different place. An integration clause. Obviously, signing a contract is not a static event. It's usually the result of a lot of negotiation. And what the integration clause says is the contract is what's inside this contract. It's what's written on this piece of paper. Whatever was said in negotiations, whatever was written in emails before, if it's not in the contract, it's not part of the contract. And so it's important on the one hand to make sure that what's written is what you agreed to, and on the other hand that everybody is aware that if there's this integration clause, that nothing that's not in the contract, things that were left out is okay. You can have a dispute resolution clause, and this is, you'll see a lot of times an arbitration clause where the parties agree that if there is a dispute about the contract, you won't go to court, at least immediately. You'll go to a mediator or an arbitrator to kind of resolve that dispute that way. Time is of the essence. You see this a lot in real estate or in other areas where literally time is of the essence. Something may spoil or that sort of thing. And then something we've unfortunately come up across a lot in the last 2 years is force majeure, impossibility, acts of God, that sort of thing, which I actually have. We will get into a little bit more about force majeure in a second. So you put that all together, and this is kind of the bare bones outline of what a contract typically looks like. And for those who are not on screen, I think this will be provided, this presentation will be provided to you. But you'll have a title at the top, kind of says what it is. You'll have an introduction that'll list out the parties, the dates, that sort of thing. You may have some what are called recitals, which are little notes on why the contract's being made. Not all contracts will have this, but they can be useful in sort of giving some flavor to the contract about what the intentions of the parties were going in. And then you'll have your core terms, your boilerplate, and then your signature block. A little bit more about force majeure. As I said, we've come up across quite a lot of this in the last 2 years for obvious reasons. But typically it's a clause in a contract that says if there's an act of God, both parties are released. There, if there's something that happens that neither party can control, both parties should be released of their obligations under the contract, and there's no breach on either side. Obviously, disputes come up about what constitutes an act of God. Is a pandemic an act of God? Is a local health ordinance an act of God? What are these? What qualifies? And so these sorts of things you should consider. And so copying and pasting a force majeure and act of God clause can be good, but it can get you into some trouble if not everything is considered. And then there are two sort of concepts that are similar to this, but they're not really clauses that go into a contract. They more come up if a dispute does go to litigation, for example, in a lawsuit. Impossibility and impracticability, and these are sort of defenses to performance by one side, where the circumstances of the original deal have changed so much that to complete the deal would be either literally impossible or so impracticable as to, for example, put the one party at risk of going out of business or in physical harm or that sort of thing. And so again, these aren't really clauses that go in. You don't put a clause in a contract that says subject to impossibility. But if you do have a dispute that comes up, you can, or if the other party's trying to claim, they can claim this as an excuse to performance under that contract.
Is this where COVID would come in, Mike?
So yeah, COVID, if it wasn't covered under an act of God clause, if I have seen some act of God clauses that specifically called included local health ordinances and local health emergency orders. So those would be covered under the act of God clause. For example, an event venue, if they had to cancel because of them being shut down by the local health officials, if they had this sort of clause in it, they would be released from liability. The other party would be released from liability, and they would each go their separate ways. The litigation that's come up, these are, and it's just starting to come into the courts now, and so we're starting to see decisions. But impossibility would be sort of the claim for these. Again, the example of an event venue, it was impossible for them. So even if it wasn't included in their act of God clause, they literally could not open through threat of law. So that would certainly be an argument just to give you an idea of how common these disputes are, the last major event where people cared about force majeure and acts of God was 9/11. So usually it takes some sort of big global catastrophe for people to pay attention to these sorts of clauses, but they can be, again, if you're going to put it in the contract, I would always recommend that you understand what's going in and why you're putting it in.
So the pandemic, the fire in Colorado, any of those kinds of things that make it so you just can't do it.
Yep.
Fall
Yep.
under the impossibility since you can't cover everything in the
Yep.
definition.
Yep. Yeah. The fire would be a good, my wife's in events, so I'm going to go back to the event thing. If you have an event venue that unfortunately burns down, the other side could argue, well, just build a new one. Well, that's not impossible, but that is very impracticable. So that's where the concept of impracticability would come in.
So around here it'd be flooding, but.
Right, right. As I mentioned, there are certain contracts that do need to be written, with some exception. Again, exceptions to exceptions. That's sort of the nature of the legal system we have. And some of these will almost certainly not come up in the life of an artist. Contracts made in anticipation of marriage, so a prenuptial agreement, that sort of thing, that has to be written. Contracts to purchase land, that has to be written. Contracts that cannot be performed within 1 year, that has to be written. And on that note, we kind of assume infinite effort. So if I were to hire you to cut down a forest, the law kind of makes up this fiction that you can do that in a year, regardless. But if you, on the other side, if you were hired to curate the art within an office building for a period of 3 years, that obviously cannot be completed within 1 year. So it should be written. If you're serving as a guarantor for somebody else's debts, that needs to be a written agreement. If you're the executor of the debts of an estate, that needs to be a written agreement. And then the other one that will hopefully come up for many artists is the sale of goods over $500. So if you're selling big pieces of art or that sort of thing, that should be a written agreement as well. And again, the one sort of caveat to that is if both parties have already begun performance under a contract and there's evidence that they both had the same understanding of what the agreement was, it can be assumed that there was an agreement, and so the written requirement is lessened in that case, even in these cases that fall under the statute of frauds.
So like
and when-
rental agreements would fall under land. I'm thinking what artists would do, rental agreements for studios or stages or whatever.
Yeah,
A performance agreement for a year and a half from now. A guarantor of somebody's debt, like a fiscal agent or a fiscal sponsor.
yeah. If you're running a nonprofit and you have a fiscal agent, a fiscal agent is a bit broader than just guaranteeing somebody else's debts. In most cases, I think fiscal agents actually don't guarantee the debts. They let you operate under their exemption, for example, but they won't necessarily guarantee the debts that you incur. But if you do have a patron, for example, who wants to come in and really likes your art, and you open a line of credit at an art supply store and they co-sign on that could be a guarantee of your debts. So that would need to be a written agreement. And the citations I have here, this RSMO stands for the Revised Statutes of Missouri. That's just the reference to the actual legal code of Missouri. And you can type this into your search bar, your internet search bar, and it'll come up. The entire code is online. So if you ever want to go to sleep, just pull it up and start reading.
And it's so much fun to read.
Now we'll get into the overview of intellectual property. three main types are copyrights, trademarks, and patents. Full disclosure, I'm not a patent attorney. Patent attorneys is uh, prosecuting a patent and submitting it for consideration in front of the US Patent and Trademark Office actually requires a special license, which I do not have. To qualify for the patent bar, you actually have to have undergraduate coursework in science, in some sort of science field. So I just have not taken the patent bar. So if you need a patent, I have several colleagues who do that, but I do not. And also I should mention I am only licensed in Missouri. I'm not licensed in any other state. So if you have questions about other states, I'm happy to try to find somebody for you. But if you have questions about Missouri, I'm happy to help. Copyright. This protects artistic works. And there are specific categories that are called out in the statute. So 8 categories. The first is literary, musical, and dramatic works. So which books, songs, that sort of thing, plays, pantomimes and choreographic works. Like Sarah, you said you were a dance troupe. So if you do choreography, you can copyright the choreography that you put together. Pictorial, graphic, and sculptural works, sound recordings, motion pictures and other audiovisual works, computer programs, compilations of works and derivative works, and then architectural works. And copyright, the one caveat to this is it has to be what's referred to as fixed in a tangible medium. So you've got to write it down. You can't just copyright. I have this idea for this great American novel. You actually have to write the novel to copyright it. For computer programs, writing the code for that qualifies. For sound recordings, putting it on an SD card, like a digital card, or audio tape or anything. So it is the work just has to be fixed in some sort of physical medium for it to be eligible to be protected by copyright. And this is kind of small, but this citation here, 17 USC 106. USC is shorthand for US code. So just like RSMO was Missouri code, this is actually federal code. And these are the core rights you get when you have a copyright. And there are 6 core ones. The first one is the right to reproduce the work. So making a print or making a CD, or people still use CDs. I don't know. Making copies of it. The second is to prepare derivative works. So you write a novel, you can write a screenplay for a TV show. You can create a painting based off of it. You can do all kinds of things. The right to distribute it. That's kind of the big one. That's the right to sell it. The right to perform it, if it's in one of the categories that's a performance artistic work. The right to display it, if it's one that can be displayed, and the right to transmit it, if it's audio or transmissible or AV, something like that. You can send it out over the airwaves. Copyright, the protection actually attaches upon, as I said, once you fix it in a tangible medium, but you maximize your rights by registering your copyright with the US Copyright Office. So registering with the Copyright Office, it allows you to sue for infringement. It gives you a fixed point in time. It puts people on notice that this work is in your name. It's a public registry. I typically recommend people do this at the federal level, at the US Copyright Office. You can do it at a state level. But if you're going to do that, you have to do it in every state you plan to do business. So if you've got an online business where you don't know where your customers are coming from, you'd have to register in every state. Jimena, yes, for dance choreography, it has to be fixed in a tangible medium. So whether it's a video recording of what the choreography is, or written description, I'm actually not too familiar with how one records a choreography, but It does have to be fixed in some sort of medium. You can't just say, I have this idea about this great dance. It has to be recorded in some form or fashion.
If I remember correctly, I know there's Lavin notation, which allows physical recording, sort of like a music script of choreography. And I know there are other forms. I just happen to know that one because I'm certified in it. But that is an acceptable form for copyright submission.
There you go. So once you register with the Copyright Office, you lock in those rights that I mentioned, and you then have the right to sue for infringement and collect money damages. The next category is trademark and service marks. Same thing, just trademark is used for goods, the sale of goods. Service mark is used for services. These are intended to prevent confusion in the marketplace. So a trademark or a service mark is used to identify the source of good or service. If there's a trademark, then you know that good or service comes from that particular company or person or whatever. It cannot be purely descriptive. Sort of the classic example is English leather. It's a cologne, so it can be trademarked as a cologne because it's not actually made of English leather. But if the company made products out of leather from England, they probably could not trademark that because that would be just descriptive of what it is. It is English leather. That would not be trademarkable. If once you've registered your trademark, and it's kind of the same process, I'll get into that in just a minute, but you have a duty to defend your trademark. So if you become aware, or you should know that somebody is using the same mark, you have a duty to defend. You need to send them cease and desist letters. You need to sue them to get them to stop. Otherwise, it could be considered that you've abandoned your mark, and anybody is then free to use it. Like copyright, trademark protection attaches immediately upon use in a trade or business. So as soon as you start using a name or a logo or a slogan in your trade or business, you can use a little TM, assuming nobody else is using it. And again, protection is maximized by registration. And for this, you register it through the US Patent and Trademark Office. They handle, as the name implies, both patents and trademarks. Registering a trademark is a much more intense process than registering a copyright. That you actually have to do a search to see who has trademarks, and it's done by what's called class, and that's essentially the market that it's in. As I said, this is to prevent confusion in the marketplace. And so you register a trademark in a particular class, and that can be as broad as software or as narrow as software for business consultants to maximize productivity of employees. Like it can get very specific. And so when you register a trademark, you register per class. And on the front end, that means you have to do a search, and usually you've hired an attorney to do this, and they help you prepare your application and submit that to the USPTO for consideration. And it's a long process. I just had a client, we submitted theirs back in April of last year, and we just got notification a few weeks ago about a decision. So it can take a while.
And it still has a few more months after that. The Arts Chamber applied for its trademark in February. We got notice the end of December that it passed all of its notice for complaints from others. And now we have to go through another process that shows that we're actually using it. And that can take another couple of months. Having done both copyright and trademarks, you can do them yourself. Stress on the can, but it really is, from a time perspective, easier to give it to an attorney. And copyright, for example, I'm a photographer. I can copyright all of my images at one time, once a year, so that I'm not doing it every time I go on a photo shoot kind of thing. The same if you're choreographing a dance or a program, you don't have to do it right that second. You can do a bunch of them at one time.
So the whole trademark process can take approximately a year. Is that accurate? Okay.
Especially when it's COVID.
Yeah, and that's if you've been accepted straight away. Occasionally, the examining attorney at the USPTO will come back to you in 9 months' time and say, we need more information, and you have 6 months to respond. So it can take quite a while, more than a year, sometimes 2 or even longer. But ideally, it takes less than a year to get a trademark.
The copyright is much faster. So if you're copywriting something, that's a much faster process and much less detailed, I guess would be the word, Mike.
Yeah,
You
yeah,
don't have attorneys double checking everything you just wrote, kind of thing.
right. The copyright's more of kind of a national file on artistic works, whereas the trademark filing is an actual research process to make sure people aren't using the same or similar in the same trade or business.
Okay.
And it's easy to follow up and check that, especially with Google Images these days,
Okay.
because you can do a Google image search, see if your image or your whatever it might be is out in the world. And that makes it a lot easier to do what Mike was saying about, enforcing your rights.
Yep. And once it is registered, you can use the little R with the circle in it. That's what the R means. It means registered.
Okay.
Patents, and again, I'm not a patent attorney, but if you do have something that you believe is patentable, I'm happy to make a referral. But in general, these are issued to people who have invented something that is new, useful, and non-obvious. And the bars for these 3 elements are variously high and low. New is just something substantially different. Pretty subjective standard. You can combine 2 previous ideas into one. That can be new. Useful is one of the ones that is a very low bar. It must serve some type of purpose. And I have an example coming up that demonstrates that useful is indeed a low bar. Non-obvious is not easily perceived by someone with expertise in the field. So this does have to be something that you put some thought and some research into. But these are also registered through the US Patent and Trademark Office, and this is the most intense application process of the 3 of them. It's like a trademark application on steroids. There's examining attorneys. You've got to put together an application that shows not only what your invention is, but what elements you're claiming of your invention, what elements you're not claiming, what's the state of the art in general, like what's currently out there in the market, how is yours different, how is yours useful, that sort of. So all these elements have to be in your application before you even submit it for consideration. And then there's usually a lot of back and forth. There's usually a lot more back and forth on a patent than there is on a trademark. Here's an example of a patent. And as I said, the bars are weird. This is an actual patent that was filed. It's a method for obtaining a confession from a suspected criminal. The guy on the left there is the suspected criminal. The guy sitting on the right is a police inspector of some kind. And in the middle there is a skeleton that the police inspector is speaking through, that is lit in a scary fashion, and the police inspector is speaking through the skeleton, trying to scare the suspect into admitting he committed a crime. So certainly not obvious. I don't know that I would have thought of that. Is it useful? Who knows? But there you go. New, useful, non-obvious for patents.
Maybe you need to have the patent for the toilet paper roll.
That's actually a good point. If you ever have a dispute on does the paper hang over or under,
It hangs over.
the actual patent drawing for the toilet paper roll has it hanging over. So
Oh, wow.
that's the way it was designed, folks.
Oh, gosh.
So you can make a bar bet with somebody and bet them the next drink that you know how it's supposed to be. And we went into those because one of the biggest types of contracts that creatives will have is a licensing contract, where you're actually licensing out your intellectual property to somebody else. And so when you are the licensor, when you're licensing out your IP, the considerations you want to take into account are what rights do you have? So, for example, if you have a copyright, you've got all those rights we talked about. You've got the right to reproduce, right to derivative works, distribution, performance, display, transmission. What rights are you giving up completely? Are you signing an exclusive deal for somebody to be the exclusive distributor of your rights, and you no longer have the right to pick a distributor? What rights are you renting? Are you giving somebody a non-exclusive right to distribute or copy or any one of those other things? But you can pick other people to do it. Are they buying it? Are they buying that right outright, or are they paying you an ongoing fee for it? And then what protections do you want as the licensor? Usually things like the person you're signing this contract with will protect that information if it's important to your business. Obviously, copyrights and trademarks and patents, these are all public databases, so everybody's going to have access to them, but still you want some assurance that the information will be safeguarded, and master copies, for example, of audio works will be protected and that sort of thing. The licensees won't infringe on your other rights and that sort of thing. From the flip side, if you're, what?
I was gonna say, you see this all the time. Every time you sign up for anything online, there's a licensing agreement. If you do any visual work through Fine Art America, there's a licensing agreement. You don't even have to get very fancy with publishers or anything. You license everything these days.
Yep. One of my favorite things to point out is if you use the Apple iTunes store, part of their license agreement is you agree not to use it to manufacture nuclear weapons.
Wow.
Really read the fine print for that one.
If you have been using the iTunes software to manufacture nuclear weapons, not only are you committing a federal crime, but you're probably violating your license agreement with Apple, which I don't know which I'm more scared of. So on the flip side, if you're the licensee, if you're licensing somebody else's IP, what rights are you getting outright? What rights are you renting? What rights are you not getting? What can and can't you do? But I would also, there's some considerations I would have. I would want to get some sort of indemnification that they, as the licensor, are promising that they have the rights they say they have. And if they don't, if somebody sues them and you for infringement, for example, that they will defend you in that lawsuit. Because you want to make sure that you're coming to them in good faith and saying, I want to license this, I want to do something with it, I think this is great. But you want some assurances that they've done their work on the front end, and you're just not opening yourself up to get sued by somebody else who actually did the work.
I'm not sure if this is licensing per se, but just from my own experience, like, I usually want, for my day job, which is graphic design, like I write into my contracts like that I have the right to reproduce the image of this in my portfolio. Like, because
Mhm.
some clients, if you do design work for them, they don't want you putting it in their portfolio, in your portfolio. Yeah. And they have various reasons for doing that. Like sometimes it's like you use maybe there's proprietary information that had to be used for the design. But anyway, yeah, usually when I'm working just for a freelance client, I will write it in my contract, just be sure, like I have the right to put images of this work in my website portfolio. And I imagine, and so if you're doing like a commission of artwork, that's something, you want to, do you have the right to like put this on your website and say, hey, I was commissioned to make this thing, here's a picture? Because sometimes people don't want you sharing that.
Yeah. Yeah, that's a great point, and that is, as you say, that is pretty common. And sort of a corollary to that is use of the other party's logos or slogans. So if you get commissioned to provide artwork to Apple, for their headquarters or whatever, maybe you can get the right to put their logo on your website and say, hey, I've done work for Apple. Kind of prop yourself up that way.
Yeah, I mean, just from my experience with graphic design contracts, yes. In graphic design contracts, you can absolutely say, like, I can include you in my client list.
Mm-hmm.
Does this come up too when, let's say, in a theater production or a dance production, or even on our website, these are our sponsors? I always make a point of getting verbal or written permission that says I can use their logo, or make sure that they have directly sent it instead of going out on the web and just copying it.
Yep. Yeah, that's exactly right. That would be part of the sponsorship agreement. It's kind of understood in a lot of cases, but as an attorney, I like to have things written in black and white, that we can use their logos for our own promotional purposes. And on the flip side, if you've got your own logo or slogan or trade name or whatever, you can control how it's used. You can say, I have the right to approve any advertisement that's put out with my IP in it. Or no advertisements will be put out using my IP that doesn't follow our own brand standards or things like that. So you have the right to control your own image and how it's presented for whether it's you or somebody else.
Yeah, I remember when we did the T-shirt project with the artists, we gave them, in their contract, they had right of final approval. So like we actually sent them the proof from the printer with their artwork on it saying, before we get this printed, sign off on this. Just to make sure like you approve of like the placement of your artwork and, the background color that we use. So.
Yep. So that actually concludes the formal portion. Any questions that I didn't get to? Any questions that you thought of? While you're thinking, I have put my email in the chat, and my email will also be on this presentation. Feel free to send me an email if you think of something later. But anything else?
I do have a question.
Yeah.
Well, since people, business relationships in the arts, it's usually based a lot on personal relationships and it's very touchy-feely. How would you advise someone to handle a situation where they want to get a contract from someone who wants to work with them, but that person is resistant to a written contract? Because, a lot of times you'll get, oh, come on, don't you trust me? Can't we just have a handshake? Like, how can you tell like a potential client or business partner that like, it's nothing personal, but I want a written contract?
So I'll start from the extreme case that they will absolutely not sign anything. In that case, I always recommend send a confirming email. It says, hey, like talking to you today. I'm really excited about our agreement. Here was my understanding. Let me know if you understood anything differently. Because at least then you've got something that says, hey, here's what we agreed to, even if it's not signed and fully formalized. Because again, most contracts are enforceable even if they're not written. So anything that you have that lays out that agreement helps your case later on if there's a dispute. If they're kind of wavering, I would say just be as nonchalant about it as possible. Say, hey, great, I love that I'm really excited to work with you. I love that you want to hire me. I'll send you my contract and we'll get going. I mean, if they really are, a friend and supporter of yours, they'll understand that this is a business of yours. Like, this is what you do. They wouldn't buy a car without signing a contract. So
Run for the hills.
so spoken like somebody who may have some experience in that.
I learned
Yeah.
the hard way. And then I started enforcing that there was a contract. And one particular one, they were like, well, you're going to get the money. You're going to get the money. And I just said, I don't do that anymore. And if I'm so glad I followed my intuition, because I wouldn't have gotten the money. I know that for a fact. So if the person honestly is a friend or an acquaintance, now I take it as a sign. If they are hesitant for some reason, that's a red flag for me. Otherwise, they won't have a problem with it.
Yeah, I've done the same thing in business. If you're starting to drag your feet, that's telling me something, and I need to be paying attention to that. And that was not just the arts business. I used to be a pediatric physical therapist, had contracts with school districts and businesses and insurance companies. And boy, when people started dragging their feet, they might as well have sent up a red flare that says there's a problem here.
Yeah, if they're a true supporter of yours, they'll treat it just as seriously as you do, and you shouldn't accept anything less. Obviously, as the artist and the business owner, you can make your own discretionary decisions, but as you say, sometimes your intuition is the best guide in this scenario.
Hey, Mike, I've got a question.
Yeah.
First of all, thanks for doing this. I really appreciate it. As a theater director, I'm the chance to speak to a lawyer for free is one I will take advantage of. I'm working with a couple of different playwrights, and both of them have included in their plays very specific pieces of music. And I'm trying to help them to determine whether they need to get copyright approval. One of them, a character punctuates all of his monologues with little snippets, a line from a musical. So there's probably 50 different musicals that are referenced in this one play. The other is using the music because one of the characters is a dancer, and she dances to a couple of specific pieces that are not in the public domain yet. And I'm just wondering how you would approach that if you were, working with a writer. What would you suggest for them?
Yeah, as we covered under the copyright, the right to produce derivative works is one of the rights that a copyright holder has, and these are certainly within that realm of derivative works where somebody's taking something that's familiar and kind of reworking it. There are mechanisms for licensing music, particularly. There's mechanical license, there's synchronization licenses that you can go through rights management organizations like ASCAP or BMI to get the rights to those. It can be kind of a process, I understand, but the statutory damages that you can incur if you were to get sued for infringement and lose that case can run into the hundreds of thousands, if not millions of dollars. And so the risk in a lot of cases is not worth the reward for these kinds of infringement cases.
And when a venue that is going to produce a piece has an ASCAP BMI licensing agreement, does this fall under that or no?
It depends on what their licensing agreement is. In this case, probably not. I don't know of many ASCAP BMI licenses that include this kind of derivative work in it. Usually they just include performance of the work, meaning they play the, like, for example, the music over speakers. Not the right to take it and change it and use it in a different way. So even if they had that, it's a different kind of license than a venue would have covered in their own licensing.
Okay, thanks.
I know in one that I had done, we wanted to play a piece during an art fair. And it related because it was conservation based and the music was conservation based. And for the one piece, I basically wrote the composer a letter and said, this is how we want to use it. This is what we want to use it for. It fits with your purpose, etc. And very kindly, he wrote back and said, you can use these tracks because these are ours. These tracks are not. Please don't use those. So it can be simple, but that's probably an exception.
Yeah, it's very rare that the composer or the original artist has all of the rights, even in their own music. Rights are split up among publishers and writers and any number of entities in between that get a piece, particularly of music, from the artist's brain onto the radio, for example. And so as you say, Sandy, some artists have their own. That's what Taylor Swift is doing right now. She's re-recording all of her stuff so that she holds the master recordings, which is a whole different aspect from even publishing or transmitting or even ASCAP or BMI. They're just organizations that oversee the collecting of royalties. They don't, in a lot of cases, own anything themselves. But Taylor Swift is re-recording everything so that she holds those masters, and Scooter Braun holds masters to the old stuff, and those will just exist simultaneously, but you'll have to pay different people based on what version you play in your coffee shop. So it's an incredible rat's nest of people who get paid and who collects on behalf of whom, and there are services popping up all the time to try to streamline this process. But as you would imagine, from an industry that has been around for a lot of years, more than a century in a lot of cases, there's a lot of inertia, a lot of institutional inertia for these to change. And until they do, it's just you're gonna have to deal with this.
Just out of curiosity, everybody, what arts do we have represented? Linda, you are kind of arts administration.
Yes, one is a singer. The other is it's combination podcast. Now she's writing a syndicated column, probably some type of online show. And she is very artsy. She's very, very artsy. Her house is filled with art. So it's going to be interesting to see how we incorporate all of that into this. And then I've done some things like written a children's book. So now we're looking at publishing that. So it's in that way, literary arts.
Jeremy, how about you? What arts are you into?
I am a painter, and actually I'm gonna sort of be dabbling with some sculpture as well this year. I've done a few little sculptures and I have these ideas to do that. So yeah, painter, sculptor. Yeah.
So you'll end up dealing with location contracts, exhibition contracts.
Oh, yes.
All those kinds of things.
Oh, yeah. I have several. I did a corporate, last year I did a pretty big corporate commission, and there was a lot of contract activity, an NDA, in fact, I had to sign for, because it was in a new building and photos of the construction couldn't be disseminated, that kind of thing. So it was a very interesting situation. So
Mike, is there some special consideration for who's liable if something's damaged?
That can all be put into the contract if you're doing, if you're being commissioned to create public art, for example. You'll want to think about who's in charge of site prep, who's in charge of securing the premises. If it's a piece that can be climbed on or should be climbed on, or is it interactive? Is it, you know, if it is interactive, it should be covered under somebody's premises liability, whether it's yours or the property owners. Who's in charge of upkeep? Does it require power? Does it require maintenance? Does it require cleaning? Who's in charge of that? How should that be done? If it's made of special materials that can only be cleaned a certain way. You know, you as the artist will be more familiar with how your art should be treated or how you want it to be treated. And so thinking through that process will be a good guide on how the contract should go. And that's typically what I ask when clients come to me, you know, whether they have a contract that they've been using for years and they copied and pasted from the internet and I'm reviewing it, or if I'm drafting one, you know, fresh from nothing. I tend to ask them, how does this fit into your business model? I mean, a lot of times it's straightforward. You know, I'm selling this thing and I do it a lot, so I want a template or whatever. But occasionally I do get, you know, things like that where it's like a public commission where you got to think through sort of the whole life cycle of the project and assign, as I said, each of those rights and responsibilities and liabilities to one of the parties or the other party or both parties. And at the end of that, you have a written agreement that sort of outlines everything that needs to be done.
And I bring that up just from the experience with the Arts Chamber doing the Mask Up St. Louis project last year. We were putting masks on all these sculptures, but the art museum didn't want us putting masks on certain sculptures because they were afraid of damage to the surface of the sculpture. Public art went into a park we redid, and nobody thought about the fact that if you're going to put a 12-foot sculptural tree in a park, somebody's probably going to climb on it, but they didn't make the wells to support even the wind. It was blowing in the wind. That's what made me think of, okay, who's taking care of this thing? We're done.
Yep.
Linda, you're next on my list. What art area are you working? Oh, no, I did Linda. Sorry, Sarah, you mentioned that you're working in theater?
Yep, that's right. I'm a theater director, but I work a lot with playwrights on new work.
So writing as well.
Yes.
Did I cover everybody? That's an interesting collection. Oh, and we have painting and photography. I'm a photographer. So copyright is certainly a very big deal for us.
All right, since it looks like we're probably close to wrapping up, can I just do share screen real quick and go over our upcoming speakers for the spring, just to encourage you all to sign up. Okay, so let me pull up my PowerPoint again. So here's so just to remind you, this our speaker series, first Thursday of every month. It's free for Arts Chamber members and it's $5 to non-members. So our upcoming speakers for this spring are, we have Steve Hartman from Wehrmeyer Creative. He's a graphic designer and artist. and he's going to be presenting about Curiosus Magazine, which was a project that Where My Creative worked on with BJC Health, and it's kind of it's a publication
Mhm.
from BJC Health that integrates art with science and health. So that's going to be a really interesting discussion about like how they used art to communicate about the health and science issues that BJC Health is discussing with its team and its investors, and and then in March we have Andrew Doty. He's with Edit Right and the St. Louis Publishers Association, and he's going to be talking about everything you need to know about self-publishing. Linda, I know you mentioned one of your clients is interested in children's books, so maybe that might be something of interest to you. So that's on March 3rd, 5 again, same time, 5:30 p.m. to 7 p.m. And then in April, we have Michelle Hamilton and Nicole Dunn from Spellman Brady and Company, which is like a really big interior design firm here in St. Louis. And they're going to be talking about working with art advisors and interior designers. So if you're a visual artist and you're interested about how you can get your work in front of these big corporate clients, like, how do you get these office buildings? Companies like Spellman and Brady worked with them to like fill their office buildings with art, but how do you get in there? How do you get your artwork in there? So they'll be going over some tips and best practices. So that'll be definitely very interesting. I'm sure that'll be of interest to a lot of us. So yeah, and we're going to have, and so those are just the three most recent ones coming up, and information's on our website. You can go ahead and register. And we are continuously developing education programs. We are working on in the fall having some more in-depth workshops and classes. So if you want to share with us, topics and subjects that are relevant to you and your artistic practice that you would like to see us cover, please get in touch with us. We love hearing people's ideas, and I will pop in my email address because I'm just a board member, but I do coordinate the speaker series. So if you have some topics you'd like to see a speaker series cover, you can shoot me an email. All right. Any questions or comments before we go?
Thank you so much for this. It was very, very informative.
Oh,
I'm
thank
going to get a membership. It was very informative. Thank you.
Well, thank you for coming out and asking great questions and, being an active participant in the discussion.
Remember, the Arts Chamber is here, so a question comes up and you need it answered or need a referral to someone, please let us know, because we have lots of resources to say, oh, here's a way that might help you, or gee, that's an interesting topic. Would you like to present on it, or would you like us to find a presenter for it? The Arts Chamber is here to support the arts business side of things. So we will be publishing our class list and programs. Stay tuned for that. And we thank you all for joining us. It's been great, nice informal conversation. And we look forward to seeing you in the future. Thank you all.
Thank you,
Thanks,
everyone.
Bob.
Good night.
Good night.